At Raju Law, we don't just provide legal services, we provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every step. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving you time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello and welcome everyone. I am Sudiksha Bohra and I'm so happy where you are joining me for another episode of Immigration for All, proudly brought to you by Nora Global and powered by Kulna Tech. You might have noticed that we recently refreshed our Monday Life series with a brand new name, Immigration for All. We felt that it truly reflects our mission to make immigration knowledge clear, accessible, and helpful for everyone, no matter where they are in their journey. And here is some exciting news. We are now on Spotify and Apple Podcast. That means you can catch up on episodes anytime, whether you are on the move or winding down at home. Today we are diving into the topic that's been a lot of minds lately, the 2025 H-1B policy changes. With the current administration pushing significant reforms, there's a lot to unpack, and we are here to break it down for you. Before we jump in, feel free to share your thoughts, questions, or just say hi in the comments. We love hearing from you. Without any delay, let's welcome our guest speaker, Mr. Raju Mahajan, the principal attorney of Raju Law.
Hi, thank you, Shudiksha, for inviting me here. And I welcome all of our audiences and viewers today to discuss this topic today.
Hello, sir. I think we can directly move on to the today's topic because all of our audience are waiting, eagerly waiting for our live.
Yeah, thank you very much. Let me share my this. Yeah, all right. So, as Shudiksha said, our today's topic today is policy changes for H-1B in 2026. Fiscal year 2026. In our last week's Monday Live, we talked about the RFE changes, changes in like a practical changes. So in general, in immigration matters, there's like a two kinds of changes. One is like a policy level changes, another one is practice level changes. So usually policy level changes are like a big picture, like an idea level kind of changes. And then USCIS officers, based on these policies, they also acts in a certain way. So usually what we do, we receive RFEs, approval letter, denial letter from USCIS, and we kind of try to understand what is the practice level changes in USCIS work in a particular category, like in H-1B, NIW, or EB-1 kind of things. At the same time, me being attorney, I'm also actively involved with bar association and different kind of attorney groups, and I try to get idea from other attorneys, like what is the practice level changes in USCIS. So our last week's discussion about H-1B was more of like a practice level kind of changes, like what experience we had in our previous like last 1 or 2 months, and that we discussed in our last week's video. Today we are going to talk about the policy level changes, like in a big picture, like idea level kind of changes in H-1B visa categories. So these are two different things. I try to make it easy for you to understand like what is the difference between last week's video and this week's video. So last week we discussed about more of a practical kind of changes, like a practice level changes, and today we're going to talk about policy level changes. That being said, let's move to the next slide. Also, this presentation, we do live broadcast in YouTube, Facebook, LinkedIn, and also audio level podcast. So anytime, anything on the slide in the presentation, those who are not watching this video, just watching our, listening to our audio, don't worry. Everything that is in the slide, I say that in my mouth in a very easy way. So even if you're not watching this video, you can still understand everything from our podcast, so don't worry about that. So, recently USCIS, they had like a modernization rule for H-1B, and one of the key element of this modernization rule is revised definition of specialty occupation. So specialty occupation is really, really key term in H-1B application. So I advise all of you who are interested about H-1B, no matter you are a beneficiary or a petitioner, this is a very important term for you to understand. By the way, if you do not know who is the petitioner and who is a beneficiary, let me explain. Beneficiary are the one who will be employee who will work under H-1B, they are the beneficiary. And employer who are going to employ you, like the owner or CEO or HR person, you are the petitioner. So no matter you are a petitioner or you are a beneficiary, specialty occupation term is very important for you. So I advise all of you to pay special attention to this term, specialty occupation. So what are the changes? USCIS made a clarification of the term normally. Previously, the term normally was very vaguely defined. So a lot of peoples, they had question about, hey, what do you mean by normally? So now the term normally is more explicitly defined as usual, typical, common, or routine. Meaning, like the job that they're going to hire you, this is the usual kind of work you do under this kind of designation. It's a very usual, typical, common, or routine kind of work for this business, for this position, and for that job they are going to hire you. So normally is very easy. Now it's very clarified, very easy to understand compared to previous definition of normally. So this is a new change. Another change is acceptance of related degree. Employers are now permitted to consider a range of related degrees for a given position as long as the connection between the degree field and the job is logical. Meaning, previously, like, if it was like a kind of IT job, and even like within the IT industry, if it was like a very specific to cybersecurity kind of job, they required you to have a degree exactly in cybersecurity. Now the field is wide open, meaning anybody who has some kind of connection, logical connection with cybersecurity, you can apply for this job, and your sponsor can apply you for H-1B for that particular position. So this is another great thing. Now they're accepting wide range of degree that is logically connected with this job, which is also a very good thing for H-1B application. There's a flexibility for nonprofit and government research organizations under this new policy. The new policy extends additional flexibility to nonprofit and governmental research organizations, simplifying compliance and fostering innovation. While details on specific accommodations are still emerging, these organizations are expected to benefit from a more streamlined application process and fewer bureaucratic hurdles. So, in general, nonprofit organizations and government research organizations, they had like some benefit before, like, there's no lottery process, they can apply any time of the year, which is a very good thing. However, under the new policy, it's even better now to I cannot see the PowerPoint. I don't know why. Our tech person, can you please make sure that I can see the PowerPoint? So sorry for the technical. Okay, let me try to add. Yeah, now it's better. So sorry for the interruption, folks. We had like a technical glitch. So the thing is, as I said previously, the government organization and nonprofit, they enjoyed certain kind of benefit, but the benefit even going to be better, like more benefits now is way more flexible for them. Now we're going to the next slide. Streamline process and increase flexibility. Under this new, there's a required to submit an itinerary detailing every work site. So previously, if the job required you to go to different kind of work sites, USCIS required the employer to submit the itinerary for every specific work site. Now they do not require it because they said, hey, this is the job of the company. We really don't care like in how many work sites they're working, in what days they're working. As long as they're meeting the other requirement, you do not need to submit the itinerary detailing every work site. So this is another great things. The next one is deference to prior approvals. USCIS will generally defer to a previously approved petition when adjudicating extensions, provided there are no significant changes. This is another great thing for employers. Meaning, so let's say you have sponsored a person for a certain kind of job, and there's not a huge changes in many things. When you apply for extension or any kind of any kind of new approval, they are going to make it way easier to approve it because they already adjudicated one time, they already approved it. So for this extension and other application, they are going to give you difference, meaning they're going to make it easy for you. And another streamlined process is automatic work authorization extension for F1 students. Certain F1 students transitioning to H-1B status now receive automatic work authorization extensions. So this is another great thing. Strengthened program integrity. So many people, they complain about the integrity of H-1B program. A lot of American people, they think, foreign workers, they're taking advantage, foreign employers, they're going to taking advantage of this process. So that's why USCIS is kind of like, making sure that there is no fraud or other thing. So they propose like a four things for this program. Number one is USCIS now has clearly defined authority to conduct site visit and ensure compliance. This is a very new thing. USCIS will send people to actual work site to see if someone is actually working there on site. So site visits are way more common now than before, and I recommend all employers to be really, really careful about the site visit. It happens a lot. Number two, employers must demonstrate that the petition offered is a genuine specialty occupation. A lot of time, a lot of employers, like petitioners, they will say that this is a specialty occupation job, but in the real life, the actual employees, they do different kind of work. So now USCIS wants to know that this is a genuine specialty occupation work, and they would like to make sure that petitioners must establish legal presence in the US and adhere to applicable laws. So a lot of time it happened. This is another funny thing. A lot of people, they say, how come that happened? So let's say a employer, he is not a US person, he is not in America. Let's say he is in Middle East. I'm just giving them. Let's say he is in Dubai, but he has a company here in America, and for his American company, he is going to hire someone. So employer, the petitioner, and this is like, let's say a single member kind of company, like a very small company. So the employer is not here in America. So that's a big no for now under this new policy. Petitioners must establish legal presence in the US. Well, it doesn't mean that the petitioner must be in America all the time. All it requires is to establish the legal presence requirement for H-1B application and follow all the applicable laws. So this is another new things to tackle like a different kind of immigration frauds. Number four, companies must prove a legitimate employer-employee relationship exists, clarifying the responsibilities and expectation of both parties. So this is a common scenario in, there's a lot of like IT companies. They're more of like a staffing company. So they hire people to work for a different company. So let me give you an example. Let's say ABC company is a consultancy firm. And once they hire someone, they will place the person for, let's say, Toyota Corporation, like the car making company. And a lot of time, they will show the Toyota is going to sponsor this person. However, in real life, Toyota is not going to be the employer. The employer would be the consulting firm. And employee, the beneficiary, will be actually employed by the consulting firm, but he or she will actually work for Toyota. There's no problem with that. The problem is USCIS wants to know who is the employer and what is the relationship. Is Toyota the employer, or the consulting firm is the employer. If the consulting firm is the employer, then USCIS wants to know that. If Toyota is the employer, then USCIS also wants to know that. So they want to know the legitimate employer-employee relationship, and also what is the responsibilities and expectations from both parties. They want to know that. So this is another new thing for H-1B, and I recommend my clients to be careful about these things. New rule for entrepreneurs and startups. This is a great thing for entrepreneurs and startups, because now it's way more flexible, way more easy for entrepreneurs and startup owners to apply for H-1B than before. Number one, self-sponsorships. For the first time, entrepreneurs and self-sponsors for an H-1B visa, allowing them to drive their own ventures without delaying on traditional employers. So this is a great things for entrepreneurs and startup owners. Also, there's a limited duration. So this is kind of a little setback, but compared to the self-sponsorship things, I think this is okay. So self-sponsored petitions and extensions are granted for up to 18 months, not 3 years. Other H-1B applications and other extensions are for 3 years, 36 months, but for self-sponsored applications is only 18 months, providing flexibility for earliest ventures to establish themselves before seeking longer term options, which is another good thing. So entrepreneurs and startup owners, please take advantage of this thing. This is a really great things for you. H-1B lottery changes and outcomes for fiscal year 2026. So beneficiary focused selection system. This is another good thing to address the fraud. Many beneficiaries, they used to apply for 3-4 H-1B applications from different companies, different employers, and that created a lot of problem for the genuine applicants. So now it's more of a beneficiary focused selection system by ensuring each individual is only entered once, regardless of multiple applications. The selection rate increased to nearly 40%, up from 30% in previous years. So just by changing the system, the approval rate went from 30 to 40%, which is a great thing for beneficiaries. Also, increased registration fee. USCIS raised the registration fee from $10 to $215. A lot of people are complaining, but I think this is a good thing, because when it's only $10, a lot of people, a lot of employers, they applied for a lot of folks, they even don't want to hire them. So when it's a $215, they have like a less interest to apply for unnecessary applications. So this is good for beneficiaries and employers too. Fluctuating denial rates. The denial rate for continuing employment petitions has decreased, which is good, reflecting a trend towards greater consistency and reliability in adjudications. So this is another good thing. Also, so there are some other reforms that they are proposing. It's not confirmed yet, but we immigration attorneys, we are kind of thinking that this is the future of this application. So businesses, please prepare for these potential changes in future. Number one, conduct salary audits to ensure positions meet or exceeds proposed prevailing wage levels. Focus on recruiting for higher wage roles to maintain a competitive edge in the selection process. Stay informed about policy updates and proactively adjust hiring strategies. So these are the things you do not have to do at this moment, but please be prepared for this, because this is the future of H-1B applications, and you have to kind of comply with this down the line. That's why I'm mentioning it here. So that was my short presentation about H-1B policy changes for this year. If you have any question, please feel free to reach out to us. We'll be happy to answer all of your questions. Going back to Sudiksha.
Thank you so much for the presentation, Mr. Mahajan. After the short break, we will resume with the question and answer session. So, all right, everyone, we'll be taking a very short break, just 1 minute. Please take this time to stretch or grab a sip of water, and we'll be back and resuming in just a moment. See you in a minute.
At Raju Law, we are proud to offer one of our most promising services, the EB2 NIW application. With an incredible success rate of 94%, our team has helped more than 1,000 clients navigate this efficient route to permanent residency in the United States. EB2 NIW allows highly skilled professionals and individuals with exceptional abilities to apply for a green card without the need to find an employer sponsor. Whether you're a scientist, engineer, doctor, or entrepreneur, this visa offers a unique opportunity to live and work in the United States based on your qualifications and contributions. At Raju Law, we're here to guide you every step of the way, making the process seamless and stress-free. Contact Raju Law today for the free EB2NIW evaluation and start your journey.
Hello and welcome back, everyone. I hope that quick break gave you a moment of refreshment. Now, let's continue with our session. We would like to answer some questions that are from our viewers. So, moving to the first question, um, how has the cap gap extension end date changed for F1 students transitioning to H-1B, and what does this mean for their work authorization?
Yeah, so those are usually good for work authorization applications because when there's like a cap gap, you can easily transit from F1 visa to H1B visa. It is kind of good for you, so don't worry about that part. It will have like a positive impact for those like you who will transit from F1 visa to H1B visa.
Okay, thank you. Moving on to the next question. What is the updated definition of a specialty occupation under the new H-1B modernization rule?
Thank you. I just explained that in our presentation today. I advise you to watch it again. I tried my best to explain it in a short way, but yeah, if you watch this video again, you'll get this answer.
Okay. The third question is: has the itinerary requirement for H-1B petitions been eliminated, and what impact does this have?
Yeah, it is eliminated, and the good thing is, so a lot of a lot of employer, they will hire someone, and under that job you have to work in multiple work sites. So previously the employer needed to report them in how many work sites you're going to work, and how many days, how many hours. Now this requirement is gone, which is good, so that the process is way more easier now than before. So that's the only outcome from this.
Okay, thank you. The next question goes like, why did the total number of H-1B lottery registrations drop significantly in fiscal year 2026?
There are many reasons for this, and one of the main reason is as I explained, beneficiary focused selection process. So previously a single beneficiary would apply from multiple employers. Like I know people, they applied for three or four applications at the same time, same year. So now that there's only one application would be considered, that's why like a lot of people, they do not have advantage like before to apply for multiple applications. That's one of the reasons. There are many other reasons. Under the current administration, it's not a very immigration friendly, so that's another reason. There are many reasons, but the number of applications went significantly down, which is good or bad depending on your perspective, but this is the fact.
Okay, so the next question is, what is the new H-1B registration fee and why was it raised?
It is $215, and as I explained, the one of the main reason is they would like to address the fraud. There's a lot of immigration fraud in almost every sector, including H1B, and that's one of the reason. And also government wants to make some money. Even though USCIS is a very profitable branch of the government, but they would like to make some more money. That's another reason.
Okay, the next question I see here is, which F1 students are eligible for automatic work authorization extensions under the new rule?
Those who already have work authorization under OPT or CPT, once you get H1B approved, your work authorization will be automatically renewed. So that's another a group. Also, sometime if you are in a different kind of visa and you already have work authorization, if you want to transit to H1B, that will also be automatically renewed. Meaning, if you already have a work authorization, that would be automatically renewed.
Thank you. The next question is, what new enforcement powers does USCIS have to maintain H-1B program integrity?
Yeah, so they are going to visit work sites way more than before. Like even before they used to visit work site, but it was not that rigorous. Now they're going to follow it more seriously. So that's one of the enforcement. There are many, but this is one of the top.
Thank you so much. The next question is, what changes have been made to visa interview waiver eligibility?
Can you please ask the question again?
What changes have been made to visa interview waiver eligibility?
Yeah, so previously, a lot of people they used to go for visa in a renewal, and it was just they just take it in a Dropbox and they used to approve it. There was not a lot of interviews, but nowadays I see a lot of interviews. Even though you already had H-1B, you just applied for extension or like renewal. But I see that's one of the changes. There's many other changes, but that's one of the changes. And previously, in our last week's discussion, we talked about that. So if you go back and watch our video again, I think you will get better answer.
Okay, so the next question I see in the comment is, will converting from STEM OPT with an approved I-140 via NIW to H-1B allow H-1B allow individual to visit the home country?
Yeah, whether you'll be able to visit your home country or not, that's a different question. It doesn't have anything to do with H-1B. But usually what I say, if you do not have a valid visa, before you go for visit your home country, try to get some extra time, because you do not know what will happen in the embassy. So be prepared for extension of the time, because for example, let's say you have 1 month of vacation, you're going there, you're going to visit India, but surprisingly it is taking more than 1 month, so it may take longer time. That's the only thing you need to careful about. Otherwise, yeah, pretty much same like before.
Okay. The next question is, why has USCIS started issuing biometric requests for evidence in some H-1B cases?
We do not know why they did it, and sometimes they say that they need to make sure the check the background of the person. This is a very confusing thing. Like in most of the people who are already in America, their background has been vetted before, checked before, but I don't understand why the USCIS is doing it. But this is the thing, they started it.
Okay, thank you. The next question is, I am going to graduate on June 21st, 2025. When should I apply for H-1B?
Well, you cannot apply H-1B by yourself. You have to have a job, and your company is going to apply for you. So, if it is a for-profit corporation, I think your company will be able to sponsor you next year, 2026. But if it's a non-profit, they can apply anytime. But whether it's a for-profit or non-profit, that's a question for the your employer, not for you. You cannot apply by yourself. So, please talk to your employer and try to convince them to apply for you.
Okay, I think this is the last question we have. How might revived prevailing wage reforms affect H-1B hiring practices?
Yeah, so it will make the H-1B hiring a little stricter. The companies must be way more serious about the prevailing wage, audit of the wage and other things. So it is not effective yet. This is kind of something that employers need to be careful for future. It will have some impacts, and I also discussed that in our today's presentation. So if you go back and watch it again, I think you have a better idea.
Um, there pops out another question, that is E2 visa cost.
Yeah, please go ahead. Oh, E2 is a
Um,
cost. Yeah, I think yeah, E2 is a cost. So not only E2, like all of our costs are in our website. So if you go to our website, there's a button called legal fees. If you click that one, all of our services, all of our fees, everything is there. So I believe you'll be able to get the cost and everything there. But just for you, your question, I think it's 8,500 something for our fee plus government fee and USCS fee. So that's the fee.
okay, thank you so much. I think there is another question, like, what are the new H-1B policies for non-profit organizations?
Well, there's a lot of policy changes. I explained in our presentation today. If you go back, listen to it again, you'll find it. And if not, I can make a whole new presentation for nonprofits sometime later. So please stay tuned to us. We will definitely answer your question.
Okay, thank you so much. I think with that, we conclude our question and answer session. Thank you so much, Mr. Mahajan, for taking the time to answer all of the questions and for sharing your valuable insights with us.
Thank you very much. And thank you, all of our audiences, for being with us.
Thank you so much. Um, Thank you so much. A heartfelt thanks to our audience as well for your active participation and presence here today. We are excited to let you know that our next live session is scheduled for the same time next week, that is 11 a.m. EST. 9 p.m. Bangladesh time, and Nepal Standard Time we have 9:45 p.m. We look forward to seeing you again then. I'll be now signing off, and right after this, stay tuned for our immigration news of the week. Till then, have a wonderful week ahead. Thank you and take care.
Welcome to the latest episode of Weekly Immigration News by Raju Law. This week, we brought to you 4 latest developments in the immigration arena. Let's start with the headlines. Trump administration to roll out Gold Card website soon. Trump officials bar Harvard from admitting international students. Supreme Court allows Trump to end deportation protections for Venezuelans. USCIS deploys common sense tools to verify voters. Let's get into details. A new US visa program backed by Trump is nearing launch, according to Commerce Secretary Howard Lutnick. Speaking at an Axios event in Washington, D.C., Lutnick said a government website for the Gold Card visa, which offers permanent residency for a $5 million investment, will go live within days. I expect there will be a website up called trumpcard.gov in about a week, said Lutnick. He added that further program details would be released in the coming weeks. Next up, the Trump administration revoked Harvard University's certification to enroll international students, escalating tensions between the university and the White House. The move stems from a DHS record request linked to an ongoing investigation. DHS Secretary Kristen Noem notified Harvard of the immediate action. The university, which previously sued over federal attempts to alter admissions and curriculum, filed another legal challenge. A Boston federal judge quickly blocked the enforcement. International students are a vital funding source for Harvard. Next up, the U.S. Supreme Court allowed the Trump administration to end temporary protected status for nearly 350,000 Venezuelans living in the United States. The unsigned emergency order reversed a lower court ruling that blocked the administration's plan to strip protections through October 2026. The decision allows deportations to begin immediately, despite the fact that many Venezuelans had valid work authorization and protection from removal under a 2023 extension issued by the Biden administration. Finally, USCIS has enhanced the SAFE program, enabling state and local agencies to verify U.S. citizenship and immigration status using social security numbers. This aims to prevent non-citizens from voting and streamline voter eligibility verification. The update supports Executive Order 14248 and eliminates user fees for state and local governments starting April 1, 2025. These changes will affect many immigrants whose status is verified for voting and other public benefits.